daughter's sitting up here, so you gotta be nice to my bill.
That was last week. She saw what happened, so you're fair game now.
Okay. Thank you, Mr. Chairman. So Senate Bill 663 is what is called a vulnerable user bill. And just so the committee has an idea of how I came to this, back in 1996, I had a brain aneurysm or something and decided to ride a bicycle across the United States of America. And rode 4,000 miles across the United States. So I used to bike a lot. Ever since my Senate pager came along, I've had less time to do that. But cycling is a very popular form of not only exercise but transportation in Northern Virginia, and also an increasing mode of transportation, not just in Northern Virginia but the entire United States, and I'm sure in many of the other localities in Virginia. The seat I represent, or at least the delegate seat I represent, I haven't done the stats for my Senate district yet, but the 44th district in the House of Delegates averages double the pedestrian fatalities of any of the statewide average. There's a lot of people that walk around to get places, either because they don't have a car or can't afford a car, or they choose to walk, and many of them end up being either severely injured or killed. And nationally, there's been a lot of growth. According to the statistics I was able to pull online, the number of people cycling and walking has doubled since 1995. 12% of all trips today are by bicycle or foot, and you're seeing more and more of that. I just saw an article today published by the University of Virginia on their census blog called StatChat, which is their Weldon Cooper Center's public means of communication, and they pointed out that Alexandria is actually one of the fastest growing localities in all of Virginia. We are seeing a resurgence in our sort of inner urban cores, whether it's the city of Richmond, Roanoke, otherwise, because people are moving back to the cities. You're seeing more and more density being built in pedestrian-oriented communities and transit-oriented communities, and with that, you're seeing more and more conflicts between people, bicycles, and vehicles. And we need to, I think, bring our laws up to date for that. Nationally, what the movement has been to deal with that are states enacting what are called vulnerable user laws, and that is either having lower thresholds for I don't want to call it criminalities, we're talking about traffic offenses, but lower thresholds for guilt in those offenses, or enhanced penalties for people who are in a vulnerable situation relative to an automobile, to incentivize people to take more appropriate care when they're driving around and have other people around them, which is a lot easier to injure or kill. Nationally, we had 4,200 pedestrian injuries 4,200 pedestrian accidents, 4,200 pedestrian deaths, can't be right. I have 70,000 pedestrian injuries, 4,200 maybe pedestrian deaths nationally, 620 cycling deaths nationally, 52,000 injured in Virginia. Last year we had 746 bike car accidents, 712 people hurt, 12 cyclists killed. I don't have the stats for pedestrians yet, but pedestrians are typically more than that. So the law you have, and I would just note, the law I have in front of you, basically what it does is it defines a vulnerable road user as either pedestrian, cyclist, somebody who's in an electric personal assisted mobility device, which is defined in the code, electric powered bicycle, wheelchair, skateboard, roller, inline skates, foot scooter, animal or animal drawn vehicles. We got the farmers and Mennonites covered there. But these are all defined terms in 46.2100 of the Code of Virginia, the people who it covers. Vulnerable user is the new category. And what it does is it creates a class 1 misdemeanor for anybody who operates a motor vehicle. Operation has been defined in the code, and it only applies to people driving a motor vehicle in a careless or distracted manner, and is the proximate cause of serious physical injury to a vulnerable road user. So basically, if you're in a collision with somebody and they are seriously injured, and you are driving either a careless or distracted manner and hurt them, you'd be guilty of a class 1 misdemeanor, which is a lower threshold than reckless driving. Reckless driving typically requires a higher level of culpability than careless or distracted. Careless and distracted are not defined in the code. I I did pull the Black's Law Dictionary definition of that, if anybody would like to know what that is. But that is the concept, and it's similar to what's been enacted in other states. And I would just note, this is not unprecedented in Virginia. Virginia already has on the books numerous statutes that deal with enhanced penalties or enhanced protections for people who are in a vulnerable position to vehicles. We've had enhanced fines for highway workers for years. I'm sure the chairman knows, a couple of years ago, we adopted legislation protecting police officers, law enforcement who are on the side of the road, directing cars to move over, to make sure that troopers and policemen are not in the way of harm when they're doing traffic stops. This law is perfectly consistent with that policy, which we already have adopted. I would also note that another reason that vulnerable users need help or need this enhanced level of protection is because they are often at a disadvantage when they are injured. Frequently, a cyclist or pedestrian, when they're struck, suffers concussions. They can't remember anything. They don't know who hit them. They don't know why they were hit. They're not really in a position to know what happened. And it's important that people be incentivized appropriately in those situations. I would also note that frequently the property damage is of a nature that you can't really, it's not really as clear as a car accident as to how that bike got run over, that person got hurt. So that's the bill. I think there's people here to speak in support of it. Nobody's contacted me in opposition to it, and I'm happy to answer any of the committee's questions.
All right, anyone on the committee have a question for me? Senator West.
Thank you. Scott, we have reckless driving, we have improper driving as a lesser included of that. Why would we need this on top of that? Doesn't this make it more complicated?
No, this probably would be a lesser included offense of reckless driving, I think. Reckless driving is driving in a manner that endangers driving in a manner that endangers life, limb, or property. I'm sure the gentleman is aware of the way the Supreme Court has interpreted reckless driving is that the occurrence of an accident doesn't necessarily result in a conviction for reckless driving. The threshold for this, instead of driving in a manner that endangers life, limb, or property, simply says anybody who drives while distracted or while careless, which I think is a lower threshold than reckless. It also, this requires a serious injury. Reckless doesn't. And for example, to give the gentleman another example, somebody could, for example, make I've seen pedestrians and I've seen cyclists injured by people who, for example, ran a yellow light. And inevitably, and our committee chairman might know, because I assume he had to make these decisions as a charging officer before, a lot of times I only see those people charged with running a light as opposed to reckless, because all they did was run the light. And usually, what I've always heard, some prosecutors, and the gentleman from Loudon was a prosecutor as well, some people view reckless as being more than just one traffic offense. I've heard some prosecutors tell me that they think in order for somebody to be guilty of reckless, you have to show that the person committed 2 or 3 traffic offenses together before to differentiate that case from running a light to a situation with reckless driving. So you were speeding and distracted and ran the light, not just ran the light. And so I think this I think would create a lower threshold. That's why I think reckless driving is not adequate. Most of the states have found it's not adequate, and that's what I think about it.
Well, just for a point for the committee, you lower the proof as far as the reckless manner, but you keep it as a class 1 misdemeanor, which is the same as reckless.
Correct.
And thank you, Mr. Chairman, and I would add, and you have a mandatory license suspension that could be 6 times the duration of a license suspension that would come from a reckless driving conviction.
And reckless is up to 6 months, and this would be a period not less than 1 year, no more than 3 years.
So in fact, the penalties are greater than the penalties for reckless driving.
Potentially.
And then,
Senator Weston.
Scott, there's some discussion or terminology in this bill about proximate cause. Is this a strict liability kind of a statute? I'm not sure whether we're applying a civil standard or a criminal standard, and based on that, also, if there's argument of proximate cause, is there any sort of defense for contributory negligence on the part of the vulnerable person?
The intent was not to incorporate a civil standard into a criminal statute. The approximate cause is well defined in the law. But I think the point of that was, for example, I had a case about a year ago, or maybe about 5 years ago, where I had a client hit another car, and the guy had like a broken wrist or something, went to the hospital, ended up dying, and the death wasn't caused by the accident. The death happened when he went to the hospital, something happened at the hospital, and so I didn't think somebody ought to be guilty of this unless the serious injury was a function of the collision and not something else.
I'm sorry, Mr. Chairman, just following up on that, what about the issue of contributory negligence on the part of the vulnerable person?
This doesn't reference contributory negligence, and that was not the intent.
According to counsel, this wouldn't have anything to do with the negligence. It's only dealing with the act of the reckless.
Right.
Senator Marsden.
Thank you, Mr. Chairman. This snowstorm has brought up some interesting vulnerable pedestrian kinds of situations. Just last night I was driving in the fan on a cross street, and car was moving from side to side as it slid between holes and what have you. There were people walking down the middle of the street because the sidewalks hadn't been cleared, so it was their only way to go, but essentially people should not walk in the middle of streets. So in that situation, suppose I was attempting to pass such an individual and the conditions of the road caused me to slide over, knock them down and injure them. Would this bill cover a situation like that, or would that be an officer's discretion? How would you anticipate this bill would work in a circumstance like that?
My impression is that equipment failure, road conditions are all factors that courts can consider in assessing culpability. I know, for example, if you claim equipment failure in connection with a reckless driving, it's a complete defense. That's obviously equipment failure, it's not exactly road conditions. But I think most judges would view that as, if the road was slippery, then you should be driving really slow. And you should modify your driving behavior accordingly. So, there's pedestrians in lots of places without sidewalks, and you're supposed to modify your driving behavior when you see them. That's the whole idea, which is why we passed the bill for troopers having people park, when they're trying to make stops. You're supposed to give them room. Sometimes it's not safe to pull them over, but you can only pull them over where you can pull them over, and they don't want to get hit.
Any further questions? Anyone in the audience like to speak to this?
Chairman, committee, Bud Nye, Richmond Area Bicycling Association. We've had a case like this 2 or 3 years ago where a rider got killed, and the driver, as often happens, says, "I didn't see him." And in that case, we asked the Commonwealth Attorney what would be the charges. He says, "There's nothing I can charge her with because it wasn't reckless driving," and he just left it at that. So nothing ever happened with that case. This is a statute that's in effect in 45 states. We're one of 5 that doesn't have it. We have been here by the League of American Bicyclists as a bicycling friendly state, and our last rating was 13th out of 50, which is pretty good. 2 of the items that we didn't pass on, that are on the checklist, one of them is this Vulnerable User Act, which we don't have, and the other is dooring, which we don't have. So I would suggest that it would be very helpful to us to have this pass, and I strongly would recommend that you do so. Thank you very much.
Thank you. Anyone on the committee have questions for Mr. Bott? Right. Okay, Senator Surovell, I've asked the question. I I don't think it's a class one misdemeanor for felon to move over for law enforcement. I think it's a,
That's right.
but you're bumping this up to a class one, which is higher than what we even put in place for the move over law. I don't know what that class is, but I've asked for that, but I'm almost.
I think it's just the regular traffic
I
offense.
think it is too. I don't think, yeah. Yeah, first infraction
The
after.
committee wants, the temperature of the committee is to amend the bill, but it could, I'm not.
Okay.
Uh,
Anyone else on the committee have any questions of the patron? All right. What's the pleasure of the committee?
I will move to report.
Ms. Hart?
I just made a motion to report the bill.
Yeah. Second offense on that is class one. You have to commit it and then second. It's been a motion and a second to report the bill. All in favor? Mr. Chairman. Senator Newman.
An additional concern that I think we should at least consider is not just the fact that we're making this more of a higher penalty than it is for the move over law, but also we have pretty well established law in these cases thus far. This introduces a whole new item. I would not be shocked to find out that the courts committee might want to look at this before we did it if we were to create a third category that we don't currently have. I think that we should probably take a look at this. There is a future of transportation subcommittee that's set up just for looking at these type of things in the interim, and some of these items that need a longer gestation period could take to be looked at in that way. And Mr. Chairman, with some respect for your concurrence, I would like to make a substitute motion that we send the subject matter to the future of public transportation, and we get this right before we decide to put it on the books.
I think the committee is the Transportation Accountability Commission. So there's a substitute motion. Right. There is a substitute motion to PBI with a letter for a study for the Transportation on Accountability Commission. Is there a second? It's been seconded. All right. On the substitute motion to PBI, we recommend it be studied in the Transportation Accountability Commission. All in favor say aye.
Aye.
All opposed?
No.
Record your notes.
You could have Senator Edwards